the East Dadekotopon Development Trust, has clarified that but for a specific 2-acre parcel of land, a recent Supreme Court judgment has not affected the ownership of its lands. At a press conference in Accra, the trust explained that the Supreme Court's judgment delivered on November 12, 2025, in the case between Adolf Tse Addo and Anas Aramea Anas only struck down a lease granted by a former trustee without the consent of other trustees, as the court declined to rule on the validity of the trust founding consent judgment. Board chairman of the trust, Joseph Ni Anan Lami, stressed that it was not a party to the case and that its land certificate remains valid and has been upheld by several Supreme Court decisions in 2019 and 2020.
The Supreme Court found against the claim of the plaintiff respondent. It was explicitly stated in the judgment that the Supreme Court could not grant the relief of the appellant, the first defendant, within the context of the suit before it. The reasons given was that the fundamental issues of the validity of the 2001 consent judgment of the High Court, creating the EDDT, as well as the 2015 consent judgment of the Court of Appeal, especially relative to the interests or otherwise of the Atata Ache and Numo Ofuli Kwashi families, was the subject of a suit pending at a High Court to be determined. To the extent that the Supreme Court declined to pronounce on the validity of the above judgment, the EDDT remained unaffected by the said judgment, except perhaps in respect of the subject matter of the suit, the land measuring 2 acres.